Okay, so it's a little after 7, and so I'm going to call this meeting to order. And before I have the clerk call the roll, we'd like to take a moment of silence to honor Lonnie Clark, who was a city council member who served 2 terms from 85 to 93. So if we would take a moment of silence to honor Lonnie Clark. All right. Thank you to Lonnie Clark, who served well, and we will call this meeting to order and call the roll.
Mr. Bowersox?
Here.
Mr. Jacobson?
Here.
Mr. Lewis?
Here.
Miss Marlin?
Here.
Mr. Roberts?
Here.
Mr. Smythe?
Here.
Miss Stevenson?
Present.
Mayor Pressing?
Here.
Are there any additions to the agenda? There's a correction. Number 6 is a discussion item. Are there any staff reports? Mayor?
We've been talking with the university about engaging the public on the wind turbines, and they have set up a meeting on this Thursday, December 16th. They're going to have an open house at 6 o'clock at the Urbana Civic Center, followed by a presentation at 7, which will take input from the public. So that's just the beginning of a long effort to get some more input from the public.
Okay. Anybody else from staff that has anything to report to us? Okay. Is there a motion to approve the minutes of meeting November 8th, 2010?
So moved.
Moved by Dennis,
Second.
seconded by Robert. Are there any corrections to the minutes? All those in favor?
Aye.
Opposed? That motion carries. I don't have anybody who has public input. I don't have any cards. If there is anyone who wants to give public input, if you'd fill a card at the back of the table and give it to the clerk, and she'll pass it down to me. Okay, we'll move on. Ordinance number 2010-06-046, an ordinance designating a historic landmark, 208 South Broadway Avenue, Urbana Lincoln Hotel, Historic Preservation Case, HP 2010-L-01. Robert Myers.
As you'll probably recall, we have an outstanding application to designate this property as a local historic landmark, and the application was actually submitted on February 16th, 2010. And since that time, essentially what's been taking place, the Landmark Commission, Historic Preservation Commission met on April 7th and May 5th and gave their recommendation to approve this property as a local historic landmark. The City Council met on June 7th on the case, and actually, after public input, decided to table the application. The owner was concerned, Marine Bank Springfield, that if landmark designation came in the middle of negotiations for selling the property, then it would affect the negotiations and possibly block a pending sale, depending on the views of the prospective purchaser. However, a new purchaser has stepped forward and purchased the property. And in fact, on November 1st, the City Council entered into a redevelopment agreement with the new owner, Xiaojin Yun, who goes by the name of XJ. He says, "Call me XJ." XJ and his wife, the new owners of the property, are committed to seeing this property reopened as a hotel, and committed in a couple ways, including legally. Now the city is a partner with the new owners to make sure that the property is successful and reopens as a downtown hotel. And the new owners have in fact submitted a registered preference form in favor of landmark designation, and they've told me personally that they're very much in favor of the landmark designation. Again, the Historic Preservation Commission recommended for approval, and because the designation would not affect a pending sale, city staff likewise recommends for approval for this application.
Is there any discussion, or Charlie?
Well, we've been discussing this for a long time. I don't think there's much more to discuss, so I'll move to send this to council with a recommendation for approval.
I'll second that.
It's been moved by Charlie and seconded by Dennis. Is there any discussion? Charlie?
I would like to thank everybody involved. I know that Brian and staff have worked hard on different aspects of this. Dennis has been a champion of it, and I think he wants to say a few words. So,
Well, yeah, perhaps so. Just really congratulations. This has been a long process. The hotel obviously has merit. Historically, very important to our community. Also, economically, it's wonderful to see a new owner opening it up for the very reason that we were hoping that it would open up as a hotel. I appreciate Brian Adams' effort to make it a landmark in the first place. What I've learned in this community is that we do try to do the right thing, but sometimes it takes a very long time. And we just have to be really patient, and we have to kind of wait through situations and work with people. Sometimes I'm impatient, but look at the result. We do have finally achieved a landmark here. I'm very excited, and I'm very pleased that it's going forward. And thanks, everybody.
Is there any other comments or discussion? All those in favor?
Aye.
Opposed? That motion carries. Next, we have discussion on ordinance number 2010-09-080, an ordinance designating a historic landmark, 104 North Central Avenue, the Eli Halberstadt House, historic preservation case number HP 2010L02. Robert Myers.
This also is a pending historic landmark application, and the last time we met on this subject, the owner of the property is Canaan Baptist Church, and Reverend Tatum with Canaan Baptist Church and their Canaan's attorney offered more time to continue discussing this, and suggested possibly until late January. So at the last time we talked about this, I said I would report back and give you an update on what our progress has been. At this point, city staff has put together some comments with the help of the mayor, and we're approaching Reverend Tatum and Canaan's attorney discuss some of these possibilities, but I think it would be a little premature to talk about details, because it really wouldn't be fair to talk about some of these ideas without getting some input from Canaan Baptist Church first. But I would like to report on a specific question. Charlie, you asked about liquor licenses and whether or not a school playground would be considered a school under the state liquor license code. And our legal staff looked into that, and it's, as they say, is gray at best. The reason I say that is because the state liquor code, it was first created in the 1930s, and it's been amended a lot of times, but it doesn't even include definitions for school or church. And in fact, one of our staff members called this a state liquor commissioner, someone who's on the liquor commission, and they said the liquor commissioners can't even agree among themselves what the definition of church or school is. So because of that, there's not much clarity on whether or not this would apply. However, let me offer one thing. There is something in the state liquor code that's helpful in our case. And I'll just paraphrase here. Nothing in this section shall prohibit a church or church-affiliated school located in a home rule municipality from locating within 100 feet of a property for which there is a pre-existing license to sell alcoholic liquor at retail. In these instances, the local zoning authority may, by ordinance adopted simultaneously with the granting of an initial special use zoning permit for the church or church-affiliated school, provide that the 100-foot restriction in this section shall not apply to that church or church-affiliated school and future retail liquor licenses. In other words, it may be that we're empowered by the state code to offer an exception if we're doing it through our local zoning powers in a special use permit process. So I did want to offer that. So that is something useful to know. Other than that, I can say that we've contacted Glenn Stanko, the attorney for Canaan Baptist Church, and he is setting up a meeting for us to discuss some of these options that we'd like to talk about.
Any further discussion? Eric?
So it happens that when I applied to be appointed to Alderman in Ward 2, which of course is where all this action is going on, I said that there were, among the many wonderful attributes of Ward 2, two of the most important were our preservation of our heritage, our historic and architectural heritage, and the other was the diversity reflected by the fact that within our ward we have an African American Baptist church, a Presbyterian church, a Unitarian church, a Catholic church, and a mosque. So this is like really both of these attributes, the preservation of our heritage and the diversity that's represented in our ward, are really precious to me, and they were hard won. 30 years ago or so, I was out there in the audience with a bunch of other people trying to convince, and successfully convincing the city council, that we could have a successful neighborhood with mixed zoning, that you didn't need to segregate people by economic class to have a stable, viable neighborhood. And we have achieved that. So I'm optimistic that with the skills and judgment of our staff, and in spite of a few heated words back and forth, the basic goodwill of all parties to this conversation, that we're going to come out okay.
Any other discussion? Okay, so we're gonna, is there, do we need a motion to keep this tabled, or just keep it tabled? Just keep it in committee?
You probably need to make a determination as to where you want to send it to next.
Sometime.
Can't we keep it in committee until we get the report back?
Yes, you can, but you need to make a motion to send it to the next.
I'll move to keep this in committee pending staff report.
Second motion.
It's been motioned by Charlie and seconded by Eric to keep this in committee. All those in favor?
Aye.
Opposed? That motion carries. Next, we have ordinance number 2010-12-112, an ordinance approving an amendment to an intergovernmental agreement with the City of Champaign, the Board of Trustees at the University of Illinois, and the Champaign County Regional Planning Commission for the review of signal clearance intervals, amendment targeted intersection in the Champaign-Urbana area. Bill Gray.
Very quickly, the memo and the agreement, in essence, are asking that the completion date be extended to December 31st next year. There was some delays through some of the IDOT approval process of getting this project started sooner. The data gathering and analysis have already begun. The final report should be early next year, but as a practical matter, and also in keeping with the federal monies, Highway Safety Improvement Program funding, we had to amend this agreement. So all the signatories to the agreement have to go through the same process back to their boards and councils. So we're just extending it by next year, but it'll be done before that.
I'd entertain a motion.
Move to send this to council with a recommendation for approval.
Second.
Been moved by Charlie and seconded by Diane. Are there any questions or discussion item? Okay, all those in favor?
Yes, aye.
Aye.
Opposed? That motion carries.
Thanks.
Ordinance number 2010-12-111, an ordinance amending Chapter 4, Section 426 of the Urbana City Code, Security for Impound Animals. Patrick? Okay. Police Chief Connolly?
Good evening. Actually, we were going to approach this from 3 fronts, but Ron O'Neill, the city attorney, isn't here. He was going to give us the legal perspective. But this is Chelsea Angelo, our animal control officer. She's going to give us the technical side of this thing. And basically, as the packet indicates, I'm requesting that the city council consider amending Chapter 4, Section 4-26 of the Urbana City Code to authorize the posting of security for impounded animals. And as a bit of background, we maintain an annual contract with the Champaign County Animal Control folks. And the county provides all the services for all the animals that we bring in there, domestic animals that we bring in there. And the contract allows for up to 7 days as part of the contract where the county animal control folks would be responsible for the feeding and welfare of the animals. After that, the city of Urbana would take on the responsibility at a rate of $15 a day per animal. Now, this request that's in front of you this evening was actually generated from a rather surprising phone call that I received just a week after I took position as the chief of police, where I was informed that we were going to be responsible for a $40,000 bill. Just as it turns out, we were able to negotiate it, and we got it reduced to zero. But the point was we had a rather lengthy criminal investigation. Chelsea, there's my legal rep. Chelsea received a criminal complaint about abuse and neglect of some animals during the investigation that she participated in, to the point of getting a search warrant for the residence. We recovered 32 dogs and cats that were abused and neglected. Those animals then became as evidence of part of a criminal investigation, and they were housed at the Champaign County facility. Now, unlike burglary items that are recovered in a criminal investigation, animals, there's a provision in state law that says that if within 10 days the state files a petition with the court asking the animal owner to be responsible for the care and welfare of the dogs during the portion until the criminal case is charged, then the court could authorize that, and every 30 days they would re-implement that petition. In this particular case, and I don't have all of the details, but in this particular case that didn't happen. And as a result of that, the bills compiled, and 8 months later, when the case was ultimately resolved in criminal court, that's when the bill was generated, when it was sent to our office. Now, as I said, we negotiated that away, but I think the point that the Champaign County Animal Control folks were trying to make when they sent that here, and in fact during a conversation with Stephanie Jost, the animal control coordinator for the county, that the future contracts or intergovernmental agreements we were going to be responsible after that 7 days, and they wouldn't be able to waive those things in the future. So needless to say, I immediately asked Chelsea, and we worked on this project for some time, but the simple solution to this is, because we can't control the state's attorney's office, they prioritize cases based on so many different variables, but the state's attorney's office in this particular case and in other animal cruelty cases prioritize this a little bit differently than they would, for instance, a very serious violent offense, understandably so. So what I think the best remedy for this is, in most situations, shy of the Michael Vick multimedia cases involving animals, I think the simple solution, the best solution, so that we can ensure that we don't accrue these kind of bills in the future, is to amend the city ordinance to allow us to pursue this on a city ordinance level, and then we, through our city legal office, could petition the court for the necessary documents in order to ensure that we don't accrue the bill. That's the general overview. Now, certainly, I know some of you folks have some questions, and we'll be happy to address those. And between Ron and Chelsea and I, hopefully, we'll be able to address everybody's concerns.
Diane?
Well, I had sent you some questions about this earlier, so I guess I'll just go through them and we'll see if we can get them covered. If there's medical treatment required, would that be covered by this security deposit that you will be getting from the
Chelsea, why don't you
person?
give her an overview on what?
The way that the petition of forfeiture works is when we impound the animals, typically it's for cruelty. This ordinance would be used mostly in our cruelty cases. Most of our other cases, the animals are not held past 7 days. It's only when we're going to court to find an owner unfit for the care of the animal that we end up holding them for extended periods of time. When we impound them under those circumstances, generally they're in need of basic medical care and basic everyday care. So they would receive medical treatment. Every animal that we impound gets a basic physical. That's included in our current contract with County Animal Control. And when they say basic, they mean basic physical evaluation given by a licensed state veterinarian, inoculations to prevent them from getting kennel cough or any of the other viruses they could be susceptible to while impounded. They can treat minor internal, external parasites, some minor injuries. They're just not, they don't have the facility to perform major operations or to treat things such as cancer in animals. They wouldn't be able to do an EKG on an animal. They can just do the basics. So when we request the courts, when we go into the court and are requesting a petition of forfeiture bond, which we have done on some past cases, we're asking specifically for the daily care, which would be $15 a day, which covers their housing, their food, their basic cares. But it would also cover if any of the animals have a particular medical need. Say they have heart medication that they have to take daily. Say they're diabetic, which does happen a lot of times in these cases. The money is for a specific need, and we have to provide the court with a itemized list of what these animals would need for 30 days. And the money that the judge would order, if they order the posting of bond, would go into an account feasibly here in Ron Eldridge's department, and that money would only be released to County Animal Control, or if it had to be an outside veterinarian, for the exact cost of whatever the procedure is.
And then if the owner refuses to pay, then they forfeit ownership of the animal.
That's correct.
And then what happens?
If the owner does not post the bond, they typically give them 5 to 7 days. In state cases, it's 7 business days. If that money is not posted, then at the end of the 7th day, the animals are automatically forfeited to the impounding agency so that they can either be adopted out or euthanized to prevent suffering. And then we would stop incurring costs, but the criminal and or city charges would still be in effect. We would still be going to court for that.
And I guess the other question I had was your definition of reasonable. Is that decided by you or by a veterinarian or?
Actually, it's identified in our intergovernmental agreement that, and Chelsea, which I don't believe you have,
Okay.
Ms. Marlin, but this is the agreement that between the city and the Champaign County
Okay.
Animal Control Facility. But veterinary services include, as Chelsea just described, almost verbatim, such services as rabies vaccinations, inoculations, health evaluations, treatment of minor curable diseases, spaying, neutering, and other veterinary services normally treatable by a veterinarian with the facilities at the county, but expressly not include treatment of major diseases, major trauma, also blood work and major surgery or dental work. So that's described in the contract.
Dennis?
Yeah, this is a kind of an interesting topic that hasn't come up too often. And it seems, first of all, I was wondering, and I guess you've made it clear, that your involvement in the taking care of the animals has to do specifically with your job as animal control person. This doesn't have to do with, say, a crime that's unrelated. Maybe there's a break-in or there's a death or there's some other event where there are animals left in the building and the city somehow becomes involved in what to do with them next because of lack of kin or something like
Right.
that.
Actually, we are responsible for the safekeeping of animals as well, and we would call during death investigations. We've called Chelsea at night. She came in and collected the animals for us because there's nobody else there to provide for the welfare of the animals, and then we would take them to the animal control facility.
So it has more to do than just this has to do with the city's interaction with animals in general, having to do with cases that come up with the jurisdiction of the city.
Right. This one, though, for the most part, is cruelty cases. For instance, running at large, dogs running at, we just get a call of a dog
Yeah.
running at large. Chelsea captures it, takes it to the facility. Those are handled differently. These are just cruelty and safekeeping.
So if a person has an event at their home and they're not able to take care of their animals and they ended up because they're maybe involved with a burglary situation, maybe the dog barked, maybe the dog saw something, I don't know, where the animal is placed into care, this would not apply because the conditions are different? Am I getting that right?
Right. This applies for long-term court cases because the animals are considered property under the Illinois state law, so they're subject to the same rules as other evidence. When we take them from the owner, when I obtain the warrant and take them from the owner, I have to care for those animals until the court has rendered a decision. So in most cases, such as just taking safekeeping of a person might be involved in an accident, or as you said, their home might be burglarized. Those are short-term care. We can typically work something out with the victim of a crime. We're not going to seek to have their ownership rights taken away or posting a bond. This really is just for long-term cases so that we can do something with the animals rather than having them sit there for 8 months. And if we can't get a release on them, if the owner's just simply not willing to release them, then at least this way the taxpayers aren't having to pay $40,000 bill while this thing's going to court. It would absolutely not be used for the cases that we see on a typical basis, especially not if somebody's been the victim of a crime. We always strive to help them and the animal.
Okay, so I got one more part to this to ask now. Okay, well, thank you. You're explaining this very well. So, and this comes up from something that Diane, you had kind of actually brought forward. So, what if if you have a case where you've got neglect and cruelty through neglect, a person who, is a cat person, and has 45 cats, and they're just, trashing the house, and somebody's finally called and said, the trailer is looking bad, what can you do? And the city ends up having 23 cats to take care of. It doesn't seem likely to me that the owner is going to be more responsible after they've been certified or arrested than they were before. So it seems to me that it's going to be unlikely that anybody's going to be coming forward to pay for the 10 cats, the the 42 birds, whatever it's going to be, to rectify the situation after 7 days. So it sounds like after 7 days, unless the animals are released to adoption, we're talking about automatic euthanasia.
That might be the case for some of them. It's up to the impound agency what they decide to do with the animals. Since we don't physically care for the animals, we have no way of offering them for adoption. We don't have a facility to keep them in. And as per contract, once they are surrendered, they become the property of Champaign County. And it is up to them as to what the disposition would be. We can suggest to them or help them if there's somebody who's interested or there's a rescue group, but ultimately it's not left to us what would happen to them. And in many of these cases, when it goes to the extreme that we have seized this many animals, there are so many health problems that we just can't adopt them out.
And it does seem like the suggested treatment for them is almost like your Cadillac version of going to the vet, which even I, would think, oh, now can I afford that? Plus what, times 20?
That's
I mean,
correct.
you're talking, you said, okay, not dental, but you're talking about shots, you're talking about spaying. I mean, why would the city even consider spaying an animal that hadn't been spayed at the time? I mean,
Once
that's not one of
we-
the concerns that we would have.
Right. We have that in there because they help us with low-cost spay and neuter. People often contact my department and need help with spay neuter. So that's why that's in here. Also, if we release an animal to county and it goes up for adoption, state mandates that no animal can leave a facility until it's been sterilized. So that's why that wording, specifically spay neuter, is in there. That's more for our other programs that we offer to low-cost spay neuter clinics.
So it seems like probably the ultimate deposition of these animals is going to be that after 7 days, well, somebody else is going to take care of them. At least we're not going to be taking care of them. Is that the gist of it?
Right,
That's correct.
we're trying not to incur these huge fees because it would, the option is to try and find a way to work around these fees, or we're just simply not going to be able to impound animals on cruelty cases, and that just doesn't seem like a logistical idea. We can't just not investigate cruelty to animals, and if we find that the animals need to be impounded, they could be there a very long time, depending on how long it takes for them to get through the court system.
Okay. I just ask these questions because so many people are, care about pets.
Sure.
And in this country they do. In other
Nobody
countries they
cares
don't.
more than
but-
Chelsea does, I can tell you that.
All right.
Yeah, and we absolutely wouldn't go after somebody just because they have 10 well-cared-for animals. These are very extreme situations, which is why the state law was invented years ago to go with their Humane Care for Animals Act. This just pretty much mirrored the petition of forfeiture bond in the state law because humane societies all over the nation were going broke, entering into large-scale hoarding situations and dogfighting situations because it does take so long to get it through the court system. And then you have an animal who's languishing in a kennel for 8-9 months, and that can just be detrimental to their psyche to where at the end of the 8 months they might not be fit for adoption. So this gives the animals a bit more option, and it doesn't leave the citizens in Urbana stuck with a huge bill that's never going to be paid.
Okay. And I guess the last thing I can say is maybe Ron O'Neill can help with this is, I don't know, does our neighbor Champaign have a similar kind of a situation or agreement or something, just in comparison?
I'm not sure, so Chelsea would probably know better than I do.
The city of Champaign contracts with County Animal Control for their services. They have similar cruelty to animal statutes. All of our cruelty ordinances mirror the state ordinance in what an owner must provide. To my knowledge, the city of Champaign does not have any language in their ordinance pertaining to petition of forfeiture or bond. Now, if they went under the state law, they obviously would be able to use the state's petition of forfeiture or bond.
Thanks very much. It was very informative.
Brandon?
Yeah, so once an owner posts security and the process is over, do they get the funds back that were not spent otherwise?
Most of the, when the court orders that this money be posted, it's specifically for the exact amount of 30 days worth of care. So at the end of the month, there should be no money left over. If there is, that should carry over, and if we petition again, because you can do that every 30 days, that money should be subtracted from what you're asking for, because you're asking for a very specific amount. It's not just an arbitrary amount that you're coming up with.
Okay. Do you always know in advance what medical care, I mean, it says reasonable expenses, and it's the estimated medical care for 30 days, but what if you don't know, and all of a sudden 10 days in, you do find the animal has cancer, needs a CAT scan, needs an EKG, and 10 other things, and then the cost runs up to $40,000. Does this text allow you to go back sooner and get additional security posted as soon as you find out, or?
You would only be able to petition the courts every 30 days.
Okay.
So in that event, we would rely on the donation services of professionals in our area, most likely. And in the event that can't happen, we would petition the chief to try and locate funds.
And I would tell you, if legal became aware that there was an amount over the amount that we could lawfully recover per this ordinance, we would more than likely institute some sort of civil action against that owner. So for example, an owner brings a dog, or we sees a dog, cat, whatever, and we've done the petition, and let's say we ask the court to give us $500, I don't know, to cover for 30 days, and then all of a sudden something catastrophic happens, and in terms of trying to save that animal, if the owner does not want to release the animal to our custody so that we can make a determination as to whether or not it is suffering so badly it needs to be destroyed, and we incur some sort of cost, more than likely legal, if it's a substantial amount of money and it's worth the effort, we would go after the owner to get that. But as Chelsea pointed out, frequently the owners that you have to seize animals for neglect and cruelty don't have the means. It's like getting water from a stone, but in instances where we felt we could prevail and actually collect something, we would probably do it. So that would take care of any amount because that's what we currently do right now. This would take care of any amount that wasn't covered under the ordinance petition.
You would get the opinion of one of the professional veterinarians, and if he said, you're going to accrue a $3,000 bill, at some point we're going to have to make a decision as far as a fiscal responsibility to address that, but that would be a case-by-case situation.
Okay. As my last question along that, since we're the ones prescribing this process in our new Section I in our ordinance, can we add an additional step so that rather than it just being every 30 days and based on an estimate, can we just put more protection in there for ourselves that says that we have the right to file amended petitions with the court if the reasonable expenses change substantially?
I could talk to Kurt. Kurt Borman, my assistant city attorney, was the one who researched and drafted this, and he drafted it to a model right after the state statute.
Okay.
So I hesitate to just tell you yes.
Right.
We're a home rule, so a lot of times we can do whatever we want unless the statute says we can't. So what I will tell you is if that is something that you feel is a deal breaker for you, then I can try to address that with Kurt at another time and find out if he believes, based on his research, that that's something that we can do. My sense is that we can do it anyway, because that's what we've been doing. Part of the reason we're wanting to do this by ordinance now is so during the pendency of the case, the judge can just order it as part of the city case, as opposed to us having to file a separate civil action. But that's what we've been doing, is filing a separate civil action. So
Right.
from that standpoint, Yeah, we can go after the person to get the money. We don't need the ordinance to say that. This ordinance is just to expedite things and have the judge say right away, okay, you know, as part of, during the pendency of this, I'm ordering you to post this amount of bond to care for this animal, versus us having to file something extra.
Right.
But, yeah, I will confirm that with,
Okay.
Kurt, if you all want to send this on, if you think you want to vote it up and send it on to the council meeting, then what I can do is have Kurt check on that, and if it's an amendment that he feels comfortable based on his research adding, then we can arrange to have that language added in before it, you know, if you all tell us that you want that amendment. If somebody wants to make a motion to have that amendment added, if it's legally possible.
Yeah, that's fine with me, based on what he finds.
I'd
Thanks.
entertain a motion
So moved.
to do what?
We're going to add the language if necessary, if required.
Yes, I mean, I would think the motion would be similar, you're moving to have this language allowing for the pursuit of anything over the posted bond amount before 30 days, or language to that effect.
Yes.
If, based on the opinion of Mr. Borman, we feel that it is lawful to have that kind of language, and don't think that there's any impedance to adding that, then we can put it in before the next council meeting.
Okay.
Are we moving the initial ordinance and with the amend?
Well, I don't have a motion to move the ordinance
That's what I thought, yeah.
So-
So I can make that motion to move it
with the amendment.
with the amendment.
Second?
We have a motion
Mhm.
and a
Yes.
second.
Yeah, I have one more.
Diane?
Just, I'm still kind of fuzzy. Who actually watches the clock ticking or the expenses mounting up? Is it with the police department, or is it with legal when you have a case like this pending?
I can tell you from, as of November, whenever I got that phone call, it's Chelsea and me and legal and any
So
other
you're
five
watching it
people
more
who are
closely
going
now.
to.
Okay,
Yeah.
good. All
We're
right.
going to have a check and balance in the system. And actually, we've also arranged with the Champaign County Animal Control folks to ensure that this never happens again, that collectively we're going to address it. But it's going to start with Chelsea, then it goes, we have a case management system. Lieutenant
Okay.
Brian Serafin's in charge of that. He's been charged with monitoring that, and then our city legal is also. The good news is, with it in the hands of city legal, it can be addressed almost immediately.
If, you know, if this had been a city case, it, you know, probably would, because we don't have major felonies to prosecute like the state's attorney's office does. That's their job. So with our city case, this wouldn't drag on for 8 months. I mean, most assuredly, Kurt would be in front of the judge when our dates are up in city court, seeking to move the case along, either prosecute it, have a trial, or plead it out and have some disposition with the animals.
Is there any other discussion? So there's a motion and a second to move this ordinance, or send this ordinance with amendment to council with the recommendation for approval. All those in favor?
Aye.
Opposed? That motion carries. We have resolution number 2010-12-032R, a resolution revising a resolution regarding the provision of disposition of impounded bicycles. That's you, Mr. O'Neill? Oh, is that you too?
Dang, back again.
Bicycles and dogs.
If it's impounded, Chelsea's on the job.
They don't want anything to do with the bikes.
They got dogs riding bicycles too?
Got them from the circus.
Oh, they got them from the circus.
I can
Go ahead.
I can kind of help Chelsea out on this one. This is something that Michelle Brooks, my other assistant city attorney, was working on. Unfortunately, Michelle couldn't be here this evening due to a death in her family. So, in a nutshell, it's like this. When bikes are found or abandoned or seized for whatever reason, we usually take them and store them and try to find out if they've been stolen or not, or if they've been lost in some way. So we do a check, we wait. If they don't come up stolen, we wait 90 days and we do another check to see if they're, you know, if they might have been reported stolen that time. If they don't, then normally we could dispose of them through One way is called it used to be the Empty Tune, and they used to take the bikes. It's a not-for-profit agency that used to take the bikes for us. They don't want to do that anymore. So now these bikes are starting to accrue, and Chelsea has contacted the United Way, and they no longer have a place to have the capacity to store these bikes for long periods of time either. So they've chosen to not take them either. So now we're starting to get to the point where all these bikes are starting to accrue. A lot of them are pretty junky and need a lot of work done to them. I believe, Chelsea, correct me if I'm wrong, I believe like some of the bikes that were in better condition, the CD took 2 of them for their employees to use on duty.
Right. They've not actually taken possession of them yet, but they did choose 2 that they're interested in.
Okay.
And I've put
Which should
those
please
aside
you
to
all
make
that
them available.
city employees might be using bicycling to get around. Mr. Smythe?
Yeah.
Mr. Allsop?
We were also using the CU Bike project for a while, and they, like all of the other not-for-profit agencies, run into the same storage problems that we're currently dealing with now. And it was just by happenstance that I came across our disposition of impounded bicycles that said we would only give them to the United Ways, dated 1991. So I did get permission from them to give them to other people. So I've completely exhausted all of the not-for-profits and the CU Bike Works, and I have 80 bicycles in my impound facility that I desperately need to get rid of because we pick abandoned bicycles up almost daily, and I need the room. There have been lots of ideas. Obviously, CU Bike Works, Community Development, we would always have bikes available to them. But in a situation like this where we have 50 or 60, the only other option is to strip them of their rubber and throw them in the garbage can. But we would like to do something a little more productive with them. If the agencies such as CU Bike Works who work on them, Cunningham Children's Home, Empty Tomb, if these places can't use them, we do sell items on eBay, and we thought we could sell them as a lot and put that money back into general revenue. And we have a steady supply of bicycles, so we are not ever going to run out of bicycles for CU Bike Works or CD, but it seemed when I spoke with everyone in the bicycle community that they did not like the thought that I might just throw them away. That was just terrible. So if we sold them as a lot on eBay, ones that people can't have no use for, there might be parts on these bicycles that people could use, and they can be used in better ways than just going to the trash. Yeah.
Basically, we just need to change this resolution.
Yeah, we just need to
We need to change the
this.
resolution to allow us to dispose of them in ways other than
The
United Way.
Okay. I have a sister who lives in Philo, and she just got 3 bikes for like hardly any money.
Right, and these would be very cheap.
And
We're-
so I think it was like a day where people knew that they were having this, come get a bike for 50 cents or whatever it
Right,
was,
right.
and fix it up, and
Right, and that's exactly
or take
what
it and
this would be.
recycle it, or take it and
Yeah.
take it to Max or something like that,
Yep.
and get a few bucks for it. Anyway, that's just a suggestion.
We had thought about that. The problem is that I am in control of all things bicycle, and without a cloning device, I just simply don't have time to do everything animal related and bike related. So when it was brought to my attention that the woman, Stephanie, who does all of our eBay, she manages all of our online, that she was willing to do this for me for any bikes that I couldn't get rid of, it was just an absolute godsend. And I thought, wow, how wonderful is that?
Sure.
They're not being thrown away. People can still use them. And then we still always would have them available. You know, if CU Bike Works calls me tomorrow and says, hey, I want 10 bikes, no problem, we'll give you 10 bikes.
Sure.
We just needed something to do with the overflow.
Okay, so I would entertain a motion for this resolution.
Yeah, okay, I'll make one. Okay, I move that we forward resolution number 2010-12-032R, a resolution revising a resolution regarding the provision of disposition of impounded bicycles to the city council with approval.
Second.
It's been moved by Dennis and seconded by Eric. Is there any more discussion? Seeing none, all those in favor?
Aye.
Opposed? That motion carries. Thank you, Chelsea.
Thank you.
And last on the agenda, resolution number 2010-12-033R, a resolution approving an amended intergovernmental agreement for regional emergency coordination. And have Mike.
Thank you. You all have a memo there in front of you that I kind of did a brief outline of what the essence of this is. But basically, the regional emergency coordination group is an entity comprised of policymakers, basically University of Illinois, Champaign-Urbana, Public Health, County, that would convene in the event of an emergency, that would be making policy decisions. Also the mayor, mayor. The mayors would be involved and are involved. That would be making policy decisions should we have some sort of an event where multi-agencies from those jurisdictions would be working together. We would assemble in the Emergency Operations Center, currently in the basement of the county building at 1905 East Main, and then we would be consulted for decisions in terms of what happens progressively in the event. So there is a agreement that was written for this group. This comes from the NIMS, which some of you might be aware of, National Incident Management, which was assembled for these type of events by the federal government to kind of give us some guidelines on how to operate in these situations. What we're asking today is the group kind of felt like it was we should come to some sort of a well-defined agreement on how long each agency was required to self-sustain financially, and then at what point the agency giving the aid would then no longer be responsible for the finances if they continue to operate in the incident. Previously, there was nothing in the agreement about that, so the group felt that 5 days would be a good number of days to implement that, and then after the 5 days, the agency receiving the aid would then have to start picking up the cost for that. It does not preclude any agency from the ability of applying for and receiving state or federal aid should there be a major emergency, and the governments would then reimburse us, similar to what happened in '96 when we had the tornado here that some of us were involved in. And so if you should choose to pass the amendment, I think you have the language there that basically states that it would be up to 5 days, and after that, then it would be the responsibility of the party receiving aid to pay for it. Any questions?
Diane?
Okay.
Has there been an incident since this group was formed?
No.
No.
Is there a motion? Oh, Eric?
Is the 5 days based on mining experiences of other, people in other parts of the country who are, who have been in this situation?
No, actually, it's just kind of fairly arbitrary. In fact, some of us felt like maybe 3 days would be maybe even more appropriate time, but they actually agreed on the 5 days. I would think that 5 days would probably more than cover any incident. I think we were operating for 3 days during the tornado of '96. So no, there wasn't anything based on what had happened out there.
Mayor Pressing?
The other agencies have already approved this, right?
Yes, they have. Mhm.
So we're the last one?
We are. Mhm.
Dennis?
How far a range does our service then go out into the community?
I'm sorry, I couldn't hear you.
How far into the community does the service that we provide extend? In other words, okay, there's a disaster, you said the tornado. That was local, that was within our community here. Does this also apply then if we're going to be called to help with flooding, or something like downstate?
No. No, this only covers the participating agencies, and I don't know if you have that in front of you or not, but basically Champaign, Urbana, University of Illinois, Public Health, just the Sheriff's Office, county, just the local
So
agencies.
it's very local?
Just
Okay.
local, yes.
Okay,
Mhm.
all right.
Yes.
All right.
Any more discussion? Is there a motion?
Yeah, I'll do that. Okay, I move to forward with approval resolution number 2010-12-33R, a resolution approving an amended intergovernmental agreement for regional emergency coordination to the City Council as indicated for approval.
Second.
It's been moved by Dennis and seconded by Robert. Is there any discussion? All those in favor?
Aye.
Opposed? That motion carries. There being no further business, this meeting is adjourned.